all that is the same
It's
words?
all really lumped together. I mean,
Okay.
and it's all similar. I mean, the concept is the same. I mean, the
Okay.
underlying concept is that I'm using a performing asset, the note, as collateral to secure a loan. That's what I'm doing.
Yeah. So when we talk about the differences, right? And then the pros of doing the hypothecation side of the space is you don't own the note, right? If Nathan sells to me and I'm a new investor and he doesn't really want to deal with that problem going bad, he can sell me the payment string. It could be a year, could be 10 years. And it's really a loan against the note versus buying the note. And if it goes bad, Nathan can replace the note with a different note. He can keep paying you while he's foreclosing. It's really an IOU. Would that be accurate?
Yeah, I mean, legal IOU is a legal term, David.
Note on the note.
But you're right though. In a typical hypothecation or a loan, you have a few different ways that they're taken, but one of them would be substituting collateral, right? So I could go out in theory, substitute additional collateral or new collateral with the lender on the note that was originally pledged if it ends up being non-performing.
It's
And then
so
what are the
interesting.
pitfalls then? Like why doesn't everybody do hypothecation versus just selling a partial?
I mean, at the end of the day, right? I mean, no, it's all a numbers game, right? I mean, what is the interest rate that you're going to pay for the lender, the investor that's going to collateralize against your note versus what's the sale? When, how much money are you getting up front on the sale? Are you keeping the asset? I mean, it's all boils down to me to numbers, because legally you can structure either one of them. I mean, you can collateralize a note, you can do a partial note sale. Once you get into the nitty gritty of the documents, the assignments, where you start dealing with the representations, the warranties, that's a pretty important thing. That's one of the reasons you need an attorney. But for me, it's always a numbers game.
Do you know what the hypothecation of usury law comes into play here, where the maximum you can charge interest rate, does that come into play with the hypothecation, where the partials that there isn't any ruling?
Well, you always have to be conscious of the usury laws, right? I mean, if you have a note that's usurious, then it could be considered illegal. And so, and certainly in Texas, you've got to pay attention to that. So I would even argue that if I go out and I loan you, I give you a loan and I collateralize your note and I'm charging 25% interest, that could be usurious in my opinion. So you have to be conscious of that in any time an interest rate is taken out, because you don't want the collateralization against the note. That brings up another point as to what's the lender going to ask for, right? What type of documents are they going to have? Are they going to have a note for your note, right? Are they going to have a loan agreement? And if so, what's the interest rate going to be in there? So you still have to comply with the usury laws.
So you said loan agreement versus note. I'm presuming that is the same documentation, or is that different?
No, they're different. And so I should have said this at the start of the podcast, but the presumption here, and when we talk about note sales, when we talk about hypothecation, everything that I'm talking about is based on the assumption that there is no separate loan agreement that was done with the underlying note. Because, and I'll give you an example, in the commercial world, you have not only notes, but you have loan agreements, right? They're two different documents. And in the loan agreements are rather restrictive on what you can or cannot do. So in the commercial world, you will have loan agreements that lay out items like this note can't be sold, and so you have to read those. So today, for the purposes of this discussion, when we're talking about note partials, note hypothecation, it's on the assumption for me that there is no separate loan agreement that's been signed with the underlying note. It's a standalone note. And generally on owner finance transactions, wraps, a basic note, there isn't a separate loan agreement. You'll see loan agreements signed up for sure on commercial transactions, and possibly if there's been some sort of construction loan that was taken out, but you don't usually see those in wraps, seller finance transactions. You don't have a separate loan agreement.
Awesome. So one of the things we wanted to talk about too is, in addition to this, is the idea, and there's a question about tax repercussions. I would tell you to talk to a CPA about any of the tax part of this. We're going to stay focused on the legal side of it. But I appreciate your question, Susan. When we talk about this stuff too, one of the things that me and Nathan came up with, this concern is could you technically sell me hypothecation on a note and then hypothecate again with Nathan without me knowing?
It depends on the underlying agreement, right? I mean, it depends on the note. I mean, that's why the preparation of the documents is so critically important, because what the documents are going to control, the note is going to control, right? The assignment's going to control. So you have to, it all goes back to the documents, what they say, what they allow, what they don't allow, because they can be tailored in a certain way. So since we're keeping this in a high level general discussion, I will say it's going to depend on the documents that are drafted and created. And I will add that part of my concern as an attorney has always been the drafting of the documents. I've seen the most ridiculous notes. I've seen the most ridiculous assignments, transfers that arguably, in my opinion, aren't even valid under Texas law. So I'm gonna go right back to, and I'm not trying to pitch attorneys for business, but because I like to help, but you got to have a turn. This is such a hyper specialty, dealing with the Texas Business and Commerce Code, dealing with these certain federal laws, that you got to have an attorney draft the underlying note and the assignment.
Well, that actually goes back to what Dave was saying at the beginning. Like, we had a hard time finding somebody that could come on and talk about this. It's not just any attorney, anybody, even the attorney that you're using for foreclosures, may not know anything about this. So it is a niche within a niche within a niche. Like, this is,
it really is. I mean, and I would even say, I mean, I'm a big believer in Thomas Jefferson's quote when he said, "He who knows best knows how little he knows." I mean, I don't know everything there is to know about every aspect of law that I practice. And so you have to David's point, I mean, some of it really does depend, and you have to stay updated and abreast of all the developments and changes in the laws. It's especially in an area like this, or in real estate, frankly, just in general.
Yeah.
So I apologize for the feed. I realized that Zoom updated a thing and we can't pop out the chat, but some of the questions we came in regarding owned by retirement plans that they have to follow under the UDFI. We're going to let if you have a question about what retirement plans can or can't do, I would focus more on those kind of people out there doing that kind of stuff. We got Tim Heritage saying, showing your great resource. But Herb, I definitely would focus more on the legal side. I would definitely talk about that. And I would say that Susan asked a question regarding that she does a lot of these things. The difference has been the speed of the transaction as well as the cost. Mm-hmm. What do you say? I'm going to give you some softball questions too. Is anything part of this collateral assignment recorded in the county records?
That's easy. That's an easy softball there. Any assignment is going to need to be recorded in the property records, because you don't just want the note, right? You want the assignment of the lien, and which usually includes two liens: the vendor's lien and the deed of trust. So yes, the assignment is going to be recorded, needs to be signed by the assignor and the assignee. And there are other items that you need to check off in the assignment. But to go back to my original point, you have to understand what the representations and the warranties are going to be.
And if you do a hypothecation, is there any assignment that's recorded on that?
In a hypothecation, no, because I'm not assigning any sort of the ownership interest in the note and the lien. Now there may be a document, and generally there isn't, but there may be a document that the lender or investor wants to file a record, an affidavit of some sort, but it's not required.
And on the call, we talked about, protecting the interest in the collateral hypothecation situation. And we mentioned the fact that someone had talked to me about, hey, to protect your interest, why don't you do some title clouding and just put a second lien there for $100? And I said, that sounded good until you said no.
No, I mean, there are liens that you can file under the Texas Constitution. And then there are also what we call slander of title actions. And any attorney worth his hourly rate, if I found some $100 bogus second lien filed of record, you could rest assured I could probably sue you for slander of title if it wasn't valid, and I probably would win. So not generally a good idea.
It's crazy, but I mean, this is what's people are trying to find ways around it. What do you suggest to those people who want that comfort level of it not being double hypothecated? Because you can sue them, right?
That's a good question, David, but it's sort of, it goes back to, I've made this statement for, God, it'll be probably 15 years that I've been an attorney. The paper that you have, the document, the contract, the assignment, the deed, it's always only worth the paper it's written on unless you're willing to sue, right? So, I mean, unless I'm willing to do something about it, it's not worth anything. So, to your point, when you get in this area, the note sales, the hypothecation, you just have to be comfortable with there is risk associated with this area. And you got to be comfortable with knowing that, okay, this is the document I have. This is what it says. An attorney drafted it. Worst case, I can sue over it. I have several causes of action that I might be able to sue to enforce, and I'll do it. But again, it's only worth the paper it's written on unless I'm willing to do something about it. So.
And this goes back to, we say this so many times and over and over and over again. It's all about relationships.
Yeah.
You know your seller, know your buyer. When you've got that kind of a pre-existing relationship, man, that's going to help so many things.
The biggest issue that I see, hopefully this doesn't go off topic, but it's frankly, it's the lack of diligence by note buyers. And when they come to me, they're like, "But God, gee, Sean, I want to sue this person. I want to sue this person." And and then I sort of ask them some basic questions, like when they talk about the, did the note have a promise? Did you look at the underlying note? Was it signed by the debtor? Did it have clear terms of repayment? Right? Was it demand or was it a fixed time? Did it have a usurious interest rate? Was it an LLC? Did you check the LLC to if it's registered to do business in the state of Texas? If not, it can't do business in the state of Texas. So was it a homestead property of the underlying note? If so, in Texas, the note has to be signed by the husband and the wife if they're married, and the deed of trust, right? These are just diligent, like sort of common basic diligence items that need to be done by any note buyer or signee in Texas, at least. Well, really, U.S. I would say. But
I didn't know Texas had the married couple clause in there. That's good to know.
It's a unique thing, and because you have this property, how property is characterized, separate property versus community property. Texas is a community property state, right?
Okay.
But that's not what necessitates a spouse signing off on any sort of document, deed of trust or note. The deed of trust, certainly, it's the fact that we have what's called the homestead, right? So you're doing it to perfect the homestead interest in the property. You don't want later down the road that the original borrower on the note defaults on the note or files bankruptcy. You get into a bankruptcy and there's a challenge over the validity of the note, and you get a creative attorney that says, "Hey, by the way, spouse didn't sign off on this deed of trust, therefore the lien itself is invalid and the homestead interest isn't protected, or perfected." So that's what the homestead concept is what requires the spouse to sign off.
Yeah, I knew that in other states. I didn't know Texas. Interesting.
So
Okay.
one of the ways we thought about doing this, and I didn't pitch this before to you, is just to protect the people. The risk I find with the hypothecation is due diligence, making sure that if you bought this lien and you took it back, you can foreclose on it, the property's worth the value and everything else, but also the fact of protecting it from a buyer perspective. And my thoughts were, put the note, the mortgage, the whole collateral file, as well as the assignment of mortgage and allonge in escrow with the attorney or servicer to protect it from being resold, and having escrow instructions to protect it. Would that help protect from hypothecating with multiple people?
Yeah.
I mean, I in theory, yes, right. But I mean, it goes back to my statement a few minutes ago. It's only worth the paper it's written on unless you're willing to do something about it, right? Because putting these documents in escrow at a title company or your attorney's office or the servicer may not necessarily stop someone from going and trying to sell it again or hypothecate again, against it or collateralize against the note itself. So while that all helps, I'm not discouraging having escrow instructions. I'm not discouraging having any of that. What I'm saying is it's not going to stop really somebody unless that person has integrity and they go, "Well, geez, the document I signed says I can't do X, Y, Z, then I'm not going to do X, Y,
Sure.
Z." So to Nathan's point, it's all about relationships. It's about who you know. You want to do business with people that are going to respect the terms of your agreement. Because if they don't respect the terms of the agreement, what do you